You're well or here?
Yeah. It's good?
Okay.
Okay, good. Great. All right. Hello, test. Hello. Hello, test. Hello, good morning. Hello. Test. Okay.
Good. Amazing. Thank you.
Okay.
Okay.
Ladies and gentlemen, we kindly ask you to please take your seats as we prepare to commence.
Por favor, solicitamos a todos los asistentes que vayan tomando sus asientos.
Okay, hello. Good morning, everyone. It's a pleasure to have you today. Welcome to the third and last day of the 2025 OECD Global Roundtable on Equal Access to Justice, hosted at this beautiful space of the Royal Collections Gallery here in Madrid. Today will be the last day of this summit, a summit which is the 10th edition of this Global Roundtable on Equal Access to Justice, the first that has been held at the ministerial level, the first that has counted with high-level representation from the 5 continents. Today, we will be having some more technical roundtables, even though we still have some very high-level representation here. The sessions will be focused on how to put people, how to put the citizen at the center of justice services. And for that, we'll be discussing the most varied, different topics. We'll be discussing on how to properly invest in justice, how to properly measure that investment. But before that, I would like to welcome to the stage to Director General for Digital Transformation of the Justice Administration, Aitor Cubo, and to Tatiana Teplova, Senior Counselor and Head of Division at the OECD, to give you some opening words. Please give them a round of applause. Thank you.
Good morning. I hope you can hear me well. Right. Well, first of all, thank you for your perseverance. For those of you who have been with us for 3 days in a row, as Alejandro mentioned, this is our 10th anniversary, so this is really a celebration. And hope you actually get the spirit of the celebration as well, during these 3 days, but also today. I also would like to take a moment to recognize those who have been with us since the outset of this journey. Daniela from Italy, Jeff from Australia, Chris and Luke from the United Kingdom, our Canadian friends, Catherine, and of course many colleagues, Seçkin from Turkey, and many of you. And also, of course, it really is an enormous pleasure to have got to this level that we have so many new countries, so many new delegates, so many new friends. And of course, I should have recognized our global partners, Hill, who has been extremely supportive from the beginning, putting people in the center, and then World Justice Project. Yes, Alejandro actually said most of the points that I was going to make, and maybe just a few points. So over the past 2 days, we have built a clear trajectory. On the 12th of November, the Justice Leaders Dialogue has set the high-level political commitment for people-centered justice. I hope you remember the phrases that were repeated quite a few times by our Deputy Secretary General, by our amazing Master of Ceremony yesterday, that the reaffirmation by the Minister was that justice systems must be people-centered, data-informed, and future-ready, and that they are essential for trust, resilience, and shared prosperity. And yesterday, during the Justice Policy Forum, we explored what this could mean in practice, from using AI and data to justice for growth and competitiveness to safeguarding the rule of law. And today, we actually move into the concrete and technical conversation. So what does it mean? What tools can we have? What data do we need so that we can track progress, so that we understand where we go and how successful we are, frankly, in this journey. So we'll talk about implementation, measurement, but also financing and investment in justice. Of course, it wouldn't be the OECD if I didn't show to all of you the publications that were launched, but also these publications provide the foundation for the conversations that we will have today. This is the new implementation toolkit for the OECD recommendation on access to justice and people-centered justice. It really aims to provide know-how, but also concrete questions, self-assessment questions, data, indicators, good practices, but also lessons learned of what not to do, what are the pitfalls to avoid. So I really encourage you to use it as much as possible. And just to say that we are aiming to have it as a living document. This will be posted on the website. And again, we will be regularly collecting good practices from all of our members and partners so that this tool is as relevant as possible. We also launched a new report on a responsive rule of law. And again, as you know, the work of the OECD on access to justice is framed as part of the broader OECD initiative on reinforcing trust and democracy. And this contribution is really a direct result of the reflections on the links between trust, rule of law, and democracy. I really encourage you to have a look at this flagship report of the OECD. And of course, our policy paper on access to justice for SMEs and how effective justice systems can promote growth, can promote entrepreneurship. And yesterday we had an excellent discussion on this topic. And again, we know that there are, well, in terms of the number of businesses, more than 90% of businesses in all of our member countries, but also partner countries form the SMEs. So this is a really, really important report in terms of how to make justice systems also work for businesses and to promote productivity in economies and our societies. There are, of course, other tools. I hope you had an opportunity to grab a copy on governing with AI, on online dispute resolution mechanisms, on data governance framework. So please use these tools because, of course, we really would like to encourage all of our countries, all our partner countries, our partners, to take concrete steps in implementing provisions of the OECD recommendations, and of course, our common resolve and common drive to make a pivot to people-centered justice. So maybe a few last words. So we are, of course, working with the Justice Action Coalition and with many partners in the room on a number of additional products. The first one is measurement and indicators. Again, our partners from HEAL, from the World Justice Project, we are looking at the outcome indicators for people-centered justice. And then, of course, also working on the policy indicators. And again, there will be a session later today. So what does it mean from a systems perspective, actually, to be people-centered? So as ministers of justice, as also there was a discussion, concrete discussion on the 12th of November. So what actions need to be taken to actually make this vision a reality? And the second work stream is strengthening the case for investment. For access to justice, including financing justice systems and what are some of the arguments, but also how we need to look at our budgets if we are actually serious about people-centered justice. Are actually our public and state budgets reflective of this commitment, and what actually needs to be done in order to make sure that this is the case. And we are really pleased to be working with Canada, with Colombia, with Indonesia and South Africa, and of course would like to encourage all of the other countries who are interested in looking at how to strengthen the case for investment for access to justice. Please join this work because, again, this can also help you make the case to your ministries of finance, to your treasuries on showing why investment in this area is important. So Alejandro already mentioned that we have a full agenda today. We have an amazing group of speakers and many practitioners from all of the regions of the world, and this is really so exciting. This is the first time that we have all regions represented, which is again an amazing achievement, and this is all thanks to your commitment. So we will look at the implementation of the OECD recommendation, what is working, but also what is not working, because I had quite a few side conversations with many of you, and some of you mentioned that it's good to look at the good practices, but the most interesting thing is actually to discuss what is not working, what is actually difficult. So I encourage you to also be reflecting on the lessons learned from your countries in this regard. We will also look at the measurement, access to justice for SMEs, justice in the context of disasters, climate change, and other systemic shocks, because we do see that more and more countries experiencing these types of events, and the big question is, are our justice systems ready? What it means for the rule of law, and how to actually protect the rule of law in this context. We will also have a few regional perspectives, including Ibero-American and MENA, Middle East and African experiences, which will also bring insights on how people-centered justice is advanced in different regional contexts, but also, of course, legal and institutional traditions. And then we will have an amazing session on looking at the Spanish experience with the digital transformation. We've already heard many great examples, but here I believe this will be an opportunity to do a deep dive to understand how actually to make it happen. So looking forward to that. So with this, I encourage you to take as much use of this technical conversation that we will have here today. It will set a practical foundation, so moving from vision to actually now practical implementation and impact. Yes, so hopefully this will be, well, I'm sure this will be an amazing baseline for the next decades of our work together. Big thanks.
Hi, good morning, everyone. I will do the welcome words in Spanish, so if you want to take the... Buenos días a todos.
Good day, everyone, and welcome to this third day of our wonderful stay in this beautiful forum, this Royal Gallery, organized along with the OECD, an old friend and partner. We've also mentioned other organizations, countries, and coordinators that accompany us today. For the past 2 days, we had a top-level ministerial meeting with ministers of state, judges of Supreme Court, and ministers of justice. Now it's time to drill down on the technicalities of this moment of transformation we are witnessing. This third day is of a more technical nature. So today we need to apply these concepts. We need to put these strategic recommendations to practice and strive for results that we will measure. We can also have a closer interaction where networking is absolutely fundamental and one of the best tools to derive from events like this. Since it is going to be a long day, I would love to request a round of applause for all OECD workers and ministry workers that have made this magnificent session possible. Because today, on the third day, we are working shoulder to shoulder. One good thing about the EU is that we're in constant contact with other countries to share experiences. And that's part of the success of the Spanish initiative. We worked closely with Austria. We are working closely with Germany to learn from their organizational model change or evolution and also digitalization. And that's the kind of thing that happens in this multilateral environment. In a world where populism and undemocratic options are gaining traction, multilateralism with all regions of the world sitting together, discussing, agreeing, and learning from one another is a strengthening factor for our democracy and certainly enhances the trust of the public in their organizations, which is so vital for us. We need to make the best of this fora to advance our purpose. I've been talking to representatives from Ecuador and Paraguay for cooperation projects. I've hardly had enough time to greet the Dominican Republic, and we have cooperation projects with them. And there have been bilateral meetings between ministers and judges, because we're all in this together, and we all want to make our societies better, because justice is a pillar of the rule of law. It's not just any service, it's a fundamental factor to keep democracies alive. Justice, as we heard yesterday, is also vital for the economy of countries. A country with no legal certainty will not attract investment and will have real problems in the economic field. As we've heard from experience, a country that has no legal certainty or too much inflation causes or generates economic losses. And that's a fundamental law of economics. And we saw presentations yesterday going from the one from Silicon Valley to very specific projects. We've seen that justice needs to be updated in data and AI because we seek maximum respect of fundamental rights. We need to move on to a zero-risk model like airlines. We cannot play with risk like banks do, or we cannot speculate. We can say, well, if we make 10% profit out of this project, we can have a 1% risk and it's acceptable. But we cannot do that. We cannot send 1% of the people who go through court to jail if they're innocent. Justice drags the entire administrative and entrepreneurial tissue of a country, because the principles that apply to justice can apply to everything as long as your aim is serving citizens, keeping them at the core of your activity. We need fair, just, and equitable systems that will protect particularly the most vulnerable communities and minorities, because we're here to make people's lives better, and together we can do it. It is our responsibility to talk, to discuss, to get together, to brainstorm, and to create projects together to make the lives of our citizens better. Thank you very much.
Thank you so much, Head of Division. So we are starting with the sessions, and the first session will be all about how we should redesign justice services to put people, to put the citizen at the center. So what we'll be discussing now is how to move from that old-fashioned institution-focused approach to this new people-centered, user-centered approach. What should be the strategies? What are the most successful initiatives? For this, we have this table, and I please invite Secretary General of the Public Service of Justice of Spain to join me as the moderator. Please, Sofía Puente. It's a pleasure to have you here. Big round of applause.
Thank you. Thank you, Alejandro. As you said, this is about, we are about to begin this third day of this event organized jointly by the OECD and the Spanish Ministry of Justice. And I'll be moderating this roundtable that aims how justice institutions are rethinking service design to be more intuitive, accessible, and people-focused justice systems. So to that end, I will be joined by different speakers or panelists who I will now introduce you and invite you to join me and sit next to me. So please, the first one is Joanna Battistino, Director, Justice Initiative and Reforms from Malta. Marielle Vavier, Deputy Mayor, City of Den Haag, Netherlands. Kitipon Kitayarak, Chairman of the Board of Directors from Thailand. Rebecca Sanderford, Professor of the School of Social and Family Dynamics, Arizona State University. Daniela Piana, Professor in the Department of the Arts, Università de Bologna. And Muriel Decaux, Executive Secretary of the European Commission for the Efficiency of Justice, Council of Europe. And now I will address you in Spanish. Efectivamente, esta mesa.
Truly, this round table where we have gathered professionals and colleagues from other countries seeks to find a way to focus on citizens rather than the traditional approach of focusing on institutions. In Spain, we conceive justice as a public service, and therefore the final user, our citizens, must be the core of the system. And for that reason, my co-workers in the Ministry of Justice must have told you over and over again about the policies we've been developing for the past few years. We're introducing reforms in all aspects, not only procedural reforms that seek to service citizens, but also considering the specific situation of age, vulnerability, or level of ability or disability. We're also conducting organizational reforms seeking to make our system more agile and effective. And we're also conducting reforms in our infrastructures to make them accessible to citizens, not only physically, but also in terms of perception. When you walk into a courthouse or an official building, it can be awe-inspiring and even threatening for some. So, since technology gives us the opportunity to reach out to citizens, we're applying these reforms to our physical space too. And that's why I find it so interesting to have people from other countries tell us about their practical experiences in their own countries, because as Aitor Kubo was saying at the beginning, from our comments, others can derive good practices that they can implement in their countries. So, in the same order as I called you up on stage, I will give the floor to Joan Battistino to hear about their good practices on the matter. Floor is yours, Joanna.
Everyone, thank you for giving me this opportunity to explain a bit what Malta has been doing these past couple of years in terms of putting people at the center of their justice system. We have been introduced to people-centered justice about 4 years ago. We have completely, as a ministry, adopted the concept, and I think that is the first transformation that has to be happen. You know, you have to have a leader in your society that endorses this transformation and pushes it forward. Our ministry, I'm not ashamed to say, because now we are changing, was a very traditionally oriented ministry, working in a very traditional setup, justice setup. But for the past 4 years, our reforms are changing. And we have been putting people and the needs of people as the foremost priority in all that we have been doing. So when I was preparing for this presentation, I went over and over all the material I wanted to say, and I was conscious of the time. And I decided to bring some examples from 3 current reforms that are ongoing in our country, and perhaps explain 1 or 2 key practical aspects to this reform that are very different from what we used to do before, and also that are giving us very, very encouraging results in terms of our adoption of this people-centered philosophy that we are implementing. So at the moment, Malta is going through a long-awaited family court reform. Just to put you a bit in the picture, our court legislation has not been looked into for about 23 years, because it was always a very sensitive subject, and because when subjects are sensitive, sometimes it is easier not to touch them because they become problematic. We embraced the challenge, and I will be talking about what we have been doing and where we are. This is a reform that just before the Permanent Secretary and I came over here to Madrid, we sent for our final review, and hopefully we're going to start the implementation in the coming weeks. So this is a mature reform. Our need to reach out to people have also extended to us being participant in an OECD-led project about enhancing access to justice through people-centered justice. And Malta, within this project, is addressing 2 areas that are also relatively have not been taken care of for quite some time. One is access to justice for people with disability, which has been for a long time a hidden population within our justice system. And the other one is the reformation of the mediation services. In Malta, mediation is often associated with family mediation, which is a very, very specific type of mediation. But when we talk about mediation, where it comes to other type of cases and how mediation is reaching out to provide a valid alternative dispute resolution, it is practically non-existent. So we chose these 2 other areas, and we started also working on these areas together with other aspects that are more cross-sectional, and I will briefly, very briefly, talk about these as well. So I think one of the most important parts or changes that our ministry have embraced is the concept of reaching out to the public, hearing your stakeholders, doing public consultation, listening, really listening to the people, and actively co-create the change that needs to be done. I think if there is a defining characteristics of our family law reform was the extensive public consultation we carried out. The ministry set up a task force that came up with initial recommendations, which we then put into a public consultation, and we issued it publicly for everyone to comment about. What was different from previous public consultations? For every recommendation we leveled, we asked a number of open questions, really and truly asking the people what they want. So we were not imposing our point of view. We were saying, we want to get there, we feel these are the issues, but please tell us if we are right or wrong, what would you do different, and what would you retain? And the feedback was extremely good for Malta, because we had eventually about 76 different submissions, most of these coming from organizations, NGOs, lawyers, professionals, individuals also, individual people who are telling us about their stories. But we supplemented this with a lot of in-person meetings, because you cannot be people-centered unless you put a human touch into what you are doing. So even public consultation, you can't just, publish a document online, expect feedback and say, okay, I'm people-centered. You need to reach out, you need to touch what we call the pain points. And I think this is something that really changed also our issues and our vision of what we wanted to do. Obviously, within the family reform, there were very different, very, very meaningful and very sensitive pain points. We realized that it was not just an issue of timeliness, but we had children who were completely absent within our justice system, so the voice of children was absent. But another thing that we did not foresee was the role of other meaningful persons. So in our society, for example, the role of the grandparents as key caregivers within the family, within the context of family separation, was completely ignored by policy, procedure, and law. So these are some of the changes and some of the things we included in our reform. I think one thing that I really need to stress is that when you approach a public consultation exercise, you have to put away a bit your ego. You really have to be open to what the people tell you and really listen to the messages if you really want the reform to be people-centered. And so I think it's also important that we look into ourselves and keep, as promoters of change, constantly checking our understanding of what we are doing, because despite the fact that we want to champion people-centeredness, we keep realizing, we keep checking ourselves, we keep realizing how we can improve this. Within the persons of disability, again, there were pain points that were completely missing. So our scope within the providing access to people with disability reform was really focused on the need, not on the profession. So for us, it was not about providing users of the justice service with access to justice, but it was also, always was also to provide users, also professionals working in the justice system, about who have disabilities, to have more access to justice. And if we thought that access to justice for users who have disabilities was an issue, even more so it was when we realized that our professionals are facing a lot of obstacles when they are working into our justice system, and they have not just physical disabilities, but also many neurological or other learning disabilities. For example, there were so many case studies, so many pain points that were mentioned. So for example, one issue that came up in our public consultation together with people with disabilities was the inconsistency in the measures that we have. So for example, just a simple example, when it comes to going into our court premises, we have ramps and we have big doors so that people who are wheelchair-bound can access the court. Physical part that we were missing, we were blind to. One lawyer, when it comes to the issues of people of professionals working in the system, one lawyer told me, he told me, while I was studying law during those 4 years, I used to come nearly every day with my parents to the courthouse, walking through the corridors, mapping, he is blind, mapping the halls, the layout of the court, so that when I get my warrant as a lawyer, as a blind person, I could function within the courthouse. And again, had we not started this project, were we not asking the right questions, these would have been pain points that would have been missed once again. Public consultation is good, but I think co-creation and continuing the public consultation process is an ongoing exercise. Obviously, in the case of the family reform, we are now making our concrete recommendations. In the case of the reform of people with disability and in the case of reform of the mediation service, we are in the diagnostic phase, meaning that we're still studying, collecting data, talking to people, and coming up with possible solutions. In the case of the family reform, we not only are changing the procedures, but we are also changing the law. But I think most importantly, we are changing the culture and the mentality. And you start realizing that what you're doing is leaving an impact, not only by the number of problems and issues and aggressive emails that you receive, because people don't take easily to change, even if you are discussing it consistently with them. But also by comments that are made by different people. So, for example, one of the initiatives that we are making within the court services is we're setting up what we call a support office. And this support office is what we call the people-centered hub for our court services. So it will be the place, through our different consultation with different vulnerable groups, it goes beyond having a help desk. So this is not where you call and you have an issue and they can help you to find where is the hall or or what a paper means or whatever. This is the place where entities, people working with vulnerable groups will be able to reach out to when they have clients going to courts and they need special dedicated services. So, for example, this is the office that will be coordinating if persons with disability will be going to court and they need special requirements. They will be coordinating with the judge and they will be attending and making sure that the special requirements are taken care of. Victims of violence, drug users, but also through our various consultations, the elderly. We have in Malta, we realized we have quite a bit of a problem with another vulnerable group, which is the elderly. So not only it's difficult for them to understand the court processes, but they have also physical limitations sometimes because they can't even hear sometimes what the judge is saying. We are also supplementing, so apart from the support office, which is a structural change, we are also changing and adding, human capacity. So we are changing roles. The child advocate, the role of the child advocate in our legal system is going to change completely in order to make it really the voice of the child within our legal proceedings. But this will be accompanied not just from the legislative change, but also from other changes that are more procedural, but also policy level. So we are cooperating very closely with a number of NGOs. We are devising training programs for the judiciary in order to be more sensitive to vulnerable people, not just sensitive to people who are going separation, because that is too narrow. We want to help them communicate better with the aged, the people with disability, with children who are undergoing proceedings, with the victim of domestic violence. So we want to give them the skills. We want to give these skills also to our lawyers, irrespective of where they work, because vulnerability is not an issue that is assigned to just one court. It's something that we work with all the time, even though we don't recognize it. So we want to address that. And we want to do other activities that are more cross-cutting. So, for example, I will not go very much into detail about the digitization. We heard a lot about it yesterday, but we do have a digital justice strategy, whose one of the key strategic goals is access to justice. So digitization is a transversal tool that we'll be using in order to facilitate access to justice for everyone, even if you are not vulnerable. Another cross-cutting and very important aspect is the data collection. So we have been seriously working on upgrading our data structures. And we have become very painfully aware also, because we are working with the OECD, that still we are not capturing what we call people-centered indicators. We are not capturing the full justice journey of the people who are going to our court system. And these are things that we are going to be looking at. We are going to be reviewing again our digital structures in order to collect the correct data. Because once we have the correct data, we will be able to offer a better service and have a better understanding of the lacunas in the service provision we are doing. So I don't know if there's so much I can say. I know I'm so painfully conscious of the time. I don't want to rush, but please do ask more questions. I can go very much in detail about every point made.
This is not nice, but focus on time.
Yeah.
Okay, we have 40 minutes, so this is your turn. Marianne.
Thank you.
Thank you very much. Thank you.
Thank you. And well, it's a great honor to speak here to you today on behalf of the City of The Hague, the International City of Peace and Justice. And this is not only a title we carry with pride, but it's also a daily reminder of our responsibility to uphold these values of peace, justice, and democracy. And I think it's very, very important that I, as a local governor, am able to be speaking here today with you. Because as cities, we all know that in a couple of years, 70–80% of the world's inhabitants are living in cities, and half of them are women. So that's also something that we really be considerate of. And in 2019, our city hosted the signing of the Declaration of Equal Access to Justice for All. So it also feels very good to be here. And it's an important milestone and a guide for strategy and action. And its purpose was simple: to promote people-centered justice around the world. And we have heard that call and also taken action. And I would like to tell you something about an initiative that I've been working hard on for the last couple of 1.5–2 years. And that involves the 50% of the people living in our city, the women, because we think that women especially are vulnerable in quite a lot of cases, and especially for women, access to justice is quite a big challenge. You've been talking about the children's voices, but well, I think also that the women's voices are, well, not heard often enough. So we will be opening in a couple of weeks our first, in Dutch, vrouwenrechtswinkel. It's like a women's rights desk or a women's legal aid office. It's a one-stop shop for legal support for women. And we aim to make the legal system more accessible for women, because citizens in this demographic are often vulnerable because they do not know their rights, or because of financial dependency makes it difficult to seek legal help. And especially women in vulnerable domestic violence situations, for instance, or being financially dependent on their spouse. We find in the City of The Hague that it's very, very difficult to get access to those women, because they are often closed, behind closed doors, and we cannot find them. And because of the lack of trust, unfortunately, in our institutions and in governments, also women find it very hard to take the step and ask for help. So that's one of the reasons that we start this one-stop shop, where even women can come anonymously. They don't have to tell their name. They don't have to share their address or their social security number. They can come in and be anonymous and ask for help or talk about whatever problems they find daily. We developed this one-stop shop for legal aid for women, together with women's organizations, together with female lawyers, together with female advocacy organizations, because we think that it's very important that we have a very broad information in order to start this one-stop shop. We also only work with female legal advisors, and we provide free and confidential advice on a very wide range of topics. And it's accessible by design. No appointment is needed. Women can simply walk in, ask their questions, and be heard. And that's also, it will be a shop with no, well, it's accessible for women, and it's not government, it's just a shop where you can be whoever you are. And I think that's one of the most important things is building trust and rebuilding trust with our citizens. And we can make our institutions accessible, but we can also, so that people come to the institutions again, but we can also bring the institutions to the people, to the neighborhoods, because we think that strong neighborhoods and strong communities are built on justice, of course, obviously, as was earlier mentioned. So another initiatives that we are very proud of is the Neighborhood Justice, a judge. It's launched in 2022 together with our Ministry of Justice, the Council of the Judiciary and the National Police Force. This locally organized court brings justice closer to the people, and literally hearings are held in community spaces, easily accessible and visible to all. And the neighborhood judge focuses on collaborations and solutions. Caregivers, social workers and legal professionals work together to help citizens resolve their problems, and participation is straightforward and affordable. Solutions are aimed at encouraging change, mutual understanding and long-term well-being. The Hague is proud also to host a unique ecosystem. The Hill, you all know, is specifically worth mentioning. Their yearly Justice Matters conference is an important platform for leaders shaping the future of justice. And just a few weeks ago, The Hague hosted the 10th edition of Impact Fest. Here, this year's winner of the Access to Justice Fund was announced by law firm Pels Rijken. The award creates important momentum for innovative solutions for vulnerable groups. Our ambition does not stop there. We want to be the forerunners. Our ambition is to create structured cooperation with the most important organizations in our city. This cooperation would provide a safety net where people, not organizations, are at the center. And at the international level, we call for recognition of the vital role cities play in preventing conflict. Lasting peace is only possible when justice is not just pursued, but also visibly upheld. In this context, I want to highlight the Hague Charter on Municipal Peace, launched in 2024 at the start of the Hague's presidency of the United Cities and Local Government Network, the UCLG. This charter affirms the vital role of cities in promoting peace by tackling the root causes of violence and inequality, and by ensuring access to justice through inclusive and participatory governance. Collaboration is central to all our efforts, both with citizens directly, local organizations and international advocates. Cities are in a unique position to collaborate across sectors and directly with people. This is what makes such powerful agents of change. Cities can be living labs of innovations and solutions, places where co-creation turns ideals into reality. So, let's continue to unite our efforts across cities, governments, and communities to make justice truly accessible. Together, let us build systems that listen, empower, and protect, laying the foundations for the peaceful society we aspire to create. Let's shape the world where justice is not just an aspiration, but a lived reality for all. Thank you.
Thank you very much, Marielle. And Kitty Yarak. Yeah, right? It's your turn. Yeah, be free.
Okay. I hope you don't mind if I stand. As a former prosecutor, I feel more comfortable speaking while standing. Buenos dias. Good morning, everyone. It's a great honor for me to be invited to join this OECD Roundtable and been requested to think back on my long journey, on my commitment toward redesigning justice services. And when I try to think deeply on the first day that inspired me, I found that it's not in the meeting room, but it's in the courtroom. I think back more than 30 years ago as a young prosecutor on the day that changed my life. I remember as a young prosecutor, I believed that justice meant winning cases and send criminals to justice to serve their time. I even have a personal notebook putting the name and the years of the sentence in my personal notebook. But one day in court, when I have a chance to speak to the poor defendant while waiting the hearing, the more I listened to him, the more that I thought that something was wrong. I found the investigative file by the police weak, a lawyer unprepared and overwhelmed, and the judge saw himself as a neutral referee where he would like to be impartial on an unequal fight. On that case, I won. But I remember it really hard for me to bring myself to put the record on my personal notebook. That was the moment that I realized that sometime and oftentimes the system can be perfectly legal, but still deeply unjust. In Thailand, we had imported elements of different legal traditions, but our hybrid of inquisitor and adversarial models left the poor with almost no chance to fight on equal terms. I began to see that the real questions were not, did we follow the law, but was that just for the person standing before us? That question has guided my journey ever since through my academic work on comparative criminal procedure, drafting due process guarantee in the Constitution, leading reform in the Ministry of Justice, and recently helped establishing the Thailand Institute of Justice, or TIJ. Along the way, I learned that better laws and better organization are necessary, but they are not sufficient. Without the deeper cultural shift toward people-centered justice, reforms do not reach the life of those who need them the most. I believe justice becomes real only when people can feel it in their everyday life. Allow me to share 3 lessons from my life experience in trying to reform the justice system. Lesson 1, begin with the people. Understand them before you reform. My early courtroom experience taught me that empathy must come before enforcement. We cannot design a fair system until we understand how people experience injustice, their fears, frustrations, and the obstacles they face. In Thailand, legal needs surveys and user journey mapping revealed that most people were not looking for justice in a formal sense that we know. They were looking for help, clarity, and fair solution. Years later, when I returned to Stanford, where I finished my law degree, I visited Stanford D School and the legal design lab of Margaret Hagen, whom she spoke yesterday, and realized that the approach had a name, legal design thinking, but for me, it began simply by just listening. When you listen long enough, people will tell you how system fails them and how it can serve them better. Empathy in the end, I believe, is not a soft skill. It is the starting point of reform. Lesson number 2, build justice with people, not merely for them. In early 2000s, I was tasked with helping shift Thailand drug policy from punishment toward rehabilitation. Our prisons at the time were severely overcrowded by those who depend on drugs, and it was clear that justice system alone could not solve the problem. I turned to the communities at the time, temples, schools, and local leaders, and invite them to become co-owners of the solution. This became Thailand's first community justice network, where volunteers help prevent drug use, mediate dispute, and support rehabilitation and reintegration. We learned that when communities are empowered with dialogue, restorative practices, and cultural traditions of reconciliation, dispute can be solved early and life repair before harm escalates. So I believe that community is not periphery of justice. It is its foundation. People-centered justice in practice is restorative rather than retributive, collaborative rather than top-down, and empowering rather than controlling. When justice is co-created with people, it becomes more trusted and also far more sustainable. Lesson 3, reform system by reforming mindset and expanding ownership of justice. When we established TIJ about 14 years ago, we apply evidence-based approach, legal need research, innovation lab, and pilot project linking justice with health, education, and social services. But we also learned that system transform not only through policy, but through people. That's why TIJ invests heavily in leadership development through the Rule of Law and Development Program, which we call the ROLE program. We bring together leaders from judiciary, prosecution services, civil services, business, data science, and social innovation communities, leaders who carry people-centered problem-solving mindset to the real reform. Justice reform, in my opinion, cannot be the justice sector's work alone. When business leaders, technologists, and communities investors recognize that justice is everyone's matters, collaboration emerges across ministry, across sectors, and across generations, extending the reach of justice far beyond the courthouse. And their work speaks for itself. In Phuket, role leaders help create a trauma-informed child-centered investigative model. Another team produced Thailand's first survivor journey mapping for gender-based violence, which has evolved into an predictive early detection tool. Authors introduced human-centered design into court and strengthened reintegration pathway that restore dignity. This breakthrough, each national first, show that what become possible when leaders cross-sector recognize that justice is everyone's business. In conclusion, I would like to say that my journey began with a courtroom where I won a case, but I lost faith with the system. It now continues with a network of collaborators working to make justice something people can truly feel and understand. Justice, in my opinion, is not measured by how many cases that we win, but by how many lives that we restore. Justice does not live in ministries or in courtrooms. It lives in markets, schools, neighborhoods, and families. Every time we listen to citizens' story and respond with empathy, we rebuild a small piece of public trust. When those pieces connect, we strengthen the foundation of thriving society. And trust is the foundation of not only justice, but of democracy, prosperity, and peace. Thank you very much.
Thank you very much, Professor Ditiyarak. It's the turn of Daniela Piana.
Good morning, everybody. Thank you for the slides. So, what does it mean to have a people-centered approach in redesigning justice systems. And I stress redesigning, which means that you need to have people at the center of change. And this is extremely important in fast-changing societies and in times in which we are living transformations, especially due to the digitalization, the challenges coming from the artificial intelligence, new patterns of production, and also new inequalities. And why we may observe some experiences that have been done in Italy, simply because Italy is one of the countries that recently has been undergoing a major comprehensive reform agenda touching all the leverages of change, which means skills, substantial and procedural laws, organization, and digitalization. So, framing the governance of changing processes in a people-centered paradigm means that if the rationale of a people-centric approach is to make possible that you design the services having a knowledge of the people needs, and at the same time you know what people can do within the justice institutions, as soon as you start the change and you design and you deliver, your first variables have been changed in the meantime. So you need to square the circle and have a sort of a learning people-centric approach. Few words about the Italian experience, simply because I think that we can reason in terms of method. First point, since 2019, in Italy has been introduced what we call a data organization and governance method. It's a very simple method. You map all the data that are in the hands of the workforce within the justice institutions. You teach them how to use this data to respond to organizational questions, not simply to run the data to explore correlations. And then they apply what they learn from the data, and once they have been at the end of a change cycle, they reform and update the data themselves. So in this way, you have a sort of a living cycle between the data, the organization, their governance, but centered on the awareness of people. Secondly, this year has been for the first time applied the legal needs survey instrument in the country within the context of a spectacular opportunity provided by the DG reform through the technical support instrument. And the legal needs survey is something that joins, in a way, this need to know which are, the demands and the barriers and the experiences that in the life cycle people do have when they try to find a solution to problems. Because people do not have judicial problems, people have problems. And this has been extremely useful because once you join an adaptive learning, dynamic approach in the analysis of the needs and a dynamic approach in the analysis of planning, delivering, and learning from what you have done and update the data, this is create a sort of a virtuous circle between society and justice. This in terms of change methods, which are the leverages. And here I think that if we take seriously this people-centered approach, we need to have an integrated approach to the change process governance, which means in practice that once you adopt a reform or a reform package, you need to have in mind that change happens and takes place at different timing and pace at different levels of reality. So you would use the leverage of literacy and the awareness of public. And this is something that has been incorporated in the data organization and governance method, because each year courts that are piloting this method use the results of the analysis to communicate to the lay people, to the community, to the public, because public in the end is the real owner of the justice institutions. And this first leverage of literacy creates also the possibility to remove a barrier in the pathway that lay people experience when they try to have access to justice, how to find information, how to get oriented among complex informations and legal documents. Second leverage, the leverage of planning, but not planning in abstract, planning on the capabilities that you are going to build. And to build capabilities takes time. So you need also to plan the time that you need to wait, because the result is not the day after. It doesn't come immediately, and you need to include in your planning the time to change. And this has been, something very challenging, the mindset of people in the piloting courts. But at the end, we managed. So now, in the planning report, there is a section that is devoted to the time to wait, to reach the exact result that you want. And in the meantime, as far as people are building the capacities to change, they build also capabilities for themselves. So intrinsically, you are building human capital, because having people at the center of the governance of change processes means also to take seriously their capacity to learn, because they learn by doing the change. And the third leverage is to entrench and to standardize in a sort of impersonal, resilient method to organize the work method within the services. Because as you know, you have turnover, and the chief justices, the chief prosecutors, the leaders in the justice institutions, they resign, they go to pension, they change, office. And what happens, if you have just started to create an innovation, you have just designed a marvelous service, but then, your leader is going away. So you need to have routinized and standardized procedures in order to hand over the torch. This is part of having people at the center, which means that once people are moving, the good that you have done should remain and not be depending, on this or this person. Is for people in the abstract terms of the word. And this creates also resilience. Is this just theory? No. This is something that is ongoing. It's true, it's real. What I wanted to tell you is that this method, which is very simple in a way, because it builds on something that already exists, the data that you have in your justice statistics, the data that you have in your evidence in the courts. And in Italy, we have also a framework agreement between the justice institutions and the universities, which facilitates a lot, the field research. But the point is that piloting courts, and you should start with a small sample of piloting courts, and then create a strategy to scale up and to expand country-wise what you have reached. It works. It works because we have already experienced in 5 years the turnover. So, and this is the best test that you can do. And in fact, you check if what you have built in the past is still there, despite the fact that leaders moved away, and it is still there. So this is a good news to share in such a marvelous place, I should say, and also in a spectacular venue and opportunity, because we have been working with a lot of friends and colleagues since 2015 on access to justice, equal access to justice, people-centric justice, and so having the 5 continents all here is just a beauty. Thank you very much.
Gaëlle.
Je vais m'exprimer en français, si vous le permettez.
I will speak in French. I work at the European Council, an international organization created after the Second World War that groups 46 member states. We usually call them from the Atlantic until the Urals. The aim is to protect and defend human rights, rule of law, and democracy. The Council of Europe in the year 2002, we created the European Commission for the Efficiency of Justice. The mission was to promote the public, or justice understood as a public service. I believe this is our topic today, to create practical tools devoted to courts and professionals of the justice system, always including the users. How do we work? First, we work using judicial statistics or statistical information. For more than 20 years, we've been compiling data every year, so our data are sound and comparative in all areas of the justice system. We measure the scope of legal aid, the specificities for the victims, claims when the system is not working, the system applied to underage people, and we also include analysis of budgets, number of judicial cases, time needed for the processes. All of these are accurate and comparable data. For a long time, we created an indicator used by all European system is disposition time, the time that is theoretically needed to sort out a case at a court. If we think about the civil cases at first instance courts, this indicator is really interesting for users that go for the first time into a justice institution. This indicator says that in Europe it takes 273 days. I also took the time to think about the disposition time about other countries, and I'm sorry about Thailand, since it was not part of the study, but the time for this type of cases is 359 days in Spain, 491 in Malta, 550 in Italy, but not even 200 in the Netherlands. So when we do this type of estimate, we can see the problems of the justice system based on accurate data and knowledge. We see some specificities that belong to specific countries, and some other problems are similar to all countries. So we need to promote a responsive justice that takes good notes of the problems and then decides to implement the necessary actions to sort them out. We have different toolkits as a methodology for customer satisfaction users or satisfaction from professionals at the justice system. This tool that will be digitalized in the near future gives explanation about how to conduct objectives and consistent surveys and how to properly understand the results. Sometimes we see that courts change after these surveys, the way they take care of the children, or the way they take care of people with disabilities, or the way they train professionals that are at the reception office that didn't really know so far how to explain the process. And all those changes don't really need a large global policy, but just punctual actions. Another important area for us is communication. Communication from the courts, how to better address the users when the staff, the courthouses is usually overwhelmed by their workload. How can we explain from an objective viewpoint a judicial case? How can we get this explanation to be better than the one that users find at the social media? And therefore, our council in this regard has prepared some guidelines on the communication to the media and to the public for courts and attorneys' offices, to say who has to communicate and how to communicate on daily matters or exceptional or critical matters. We have also made some guidelines, and this is related to the first tool, about the simplification of language use with the users, avoiding formal language, also formality in the behaviors, the need to promote serene and balanced atmosphere at the hearings. And the latest tool I would like to introduce is the use of AI at different jurisdictions. Yesterday we covered this topic. Since 2018 we adopted a charter that back then it was just included 5 main principles, but since then, since 2018, we have continued working along those lines with some of you present in this room, and we have developed a resource center that compiles the AI tools officially used at the justice system, and we don't have so many tools, but they are resources that this will evolve in the future into a monitoring center for artificial intelligence that will try to provide information and warn about potential infractions or violations of fundamental rights. So as an individual going to the justice system, sometimes we discover an overwhelming world, difficult to understand, and our council, as all of you, has the role to play with or to work with national legal systems so we can give to those users guidance and accompaniment, but to make cases resolution as fast as possible, but always perfectly understood. And if I speak about accompaniment now, I would really briefly like to mention the award, the Balance of Glass, granted every 2 years to award initiatives in the justice system. We have just awarded this to the Netherlands in their first instance court system. Their objective is to accompany from the very first time at the courthouse those that have to go to court due to deaths. We believe that with this award, we might urge other states to benefit from this experience. Justice should always respect national traditions. This is very clear. The way we greet or welcome people in Finland, Morocco, and France will not be the same, but all courthouses should address equally the children, and that's different from adults. It has to be an empathetic kind of justice, as has been mentioned here, and also justice that knows beforehand who the user is. Therefore, the work of the Council has shown that this type of justice needs experience. And what do we need to have this view? First, at the courthouses, we need a system, an efficient way of managing cases. We need professionals that are not afraid of statistics, which is not always the case. Then more and more we need professionals specialized in certain areas. We need professionals that can welcome all sorts of users, and we also need lawyers and mediators that work together alongside magistrates and not on a parallel manner or even in opposition. All of this requires time, and staff at the courthouses is always overwhelmed by the high number of cases. Sometimes we implement policies to react to something that has moved society, and we and also the OECD, we need to place at the center of our concerns always the users. Thank you very much for your attention.
C'était très beau de vous entendre parler français. Très beau.
Thank you for your presentation.
Audience, do you have any questions? If not, voy a cerrar esta mesa.
I'm going to close this roundtable, go back to Spanish, that I found very interesting, and we can summarize as follows. They have all spoken about a closed justice. There's not a closed justice if we don't include the people. As it was said by Professor Daniela, we need to take into account the users of people's needs. We need to analyze data, as it was reminded by Muriel. And with all of this, we need a process that takes some time, but a process where we also have time to manage time. And the key words of this type of justice, there's no a closed justice without people, without empathy, if they don't understand us. That's why our professionals need to use a clear language, easy to be understood, and accessible language. We also need our professionals to change their mindset, and therefore to forget about certain ways of work that might not be so accommodative. And with all of this, in this justice close to the people, and I see with the privileged position of the ACPEG, where they can compare our legal systems, I believe we're all along those lines. As Muriel said, we need to incorporate in our justice systems other profiles, not only attorneys or judges. We need therapists, social workers, people that will accompany victims. In Spain, we have our victims' attention offices, and in this way, that cannot be attained overnight. It's important that all countries, all states, to put our capacity to work towards this objective, so that we can make of our justice system a public service that is closer to our users, closer to the public. Thanks a lot for your participation. It's been very inspiring to listen to all your presentations.
Thank you so much. So we'll be heading to the coffee break in just a minute. But before that, I'd like to just make a little bit of a brief overview of what we're heading to. So we have discussed about the different initiatives that we have. CEPESH Resource Center on Artificial Intelligence and Cyber Justice I've mentioned. I really recommend that you enter and check all the different initiatives there. You may find a lot of our AI initiatives there. What you will not be able to find, and that I just wanted to tell you as a little bit of a wrap-up before the coffee, is our robotic process automation initiatives. And precisely because we're talking about how to put people at the center, I just wanted to describe one of them that has been changing the way courts work. And that is the automation of the transfer of information between the case management system, which in Spain is 100% digital, and the court's bank account. So that transfer of information would be made in paper, but what we've done is that right now it's completely automated. You'll see this is something that you think maybe a little bit silly. It's just an interoperability automation that we call it. Precisely because of that automation, precisely because of making information more available to the state court lawyer, the secretary of the court who is responsible for this, we've been able to streamline the transfer of more than 8 billion euros, 8.000 millones de euros, que hemos puesto de nuevo en circulación en la economía, 8 billion euros that we've been able to put back in circulation into the economy because of actually designing digital services that had people at the center. Director Kubo was also referring to how justice is completely linked with the economy and the competitiveness of the economy. 8 billion euros is half percentage point of Spain's GDP in 2024. So just for us to continue the conversation and continue discussing our digital tools, we've had a coffee and we'll welcome you in half an hour. See you then. Thank you.
We will now take a short pause for refreshments. Please proceed to the designated area in the foyer outside the auditorium.
A continuación, realizaremos una breve pausa para el café. Les esperamos en la zona de la antesala del auditorio.
1, 2, 3. Hola, hola, hola. Es la 2, sí, sí. La 2. 1, 2, 3. Hola, hola, hola. Está igual de nivel que antes ahí en el... Uno, 2, 3. Hola, 1, 2, 3. Hola, 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 hola. Hola. 1, 2, 3. Probando. Sí, hola, hola. Probando la diadema número 2. Sí, hola, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Hola, 1, 2. Hola, 1, 2. Hola, 1, 2. Hola, 1, 2. Hola. Hola, sí, 1, 2, 3. Probando. Sí, hola, probando sonido. 1, 2, 3, 4, 5, 6. Hola, hola, 1, 2. Hola, 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 1, 2. 1, 2, 3. Probando. Sí, hola, 1, 2, 3, probando. Sí, hola, 1, 2, 3, 4, 5, 6. Hola, 1, 2, 3. 1, 2, 3, probando. 1, 2, 1, 2. 1, 2, 3, 4, 5, 6. Hola, hola, hola. Hola, 1, 2, 3. 1, 2, 3, 4, 5, 6. Hola, hola, ¿qué tal? Sí, hola, 1, 2, 3, 4, 5, 6. Hola, hola, hola. Hola, 1, 2, 3. Hola, 1, 2, 3. 1, 2, 3, 4, 5, 6. Hola. Ha mejorado, sí.
Pero luego se está escuchando el retorno del streaming, la prueba de sonido.
Porque lo tienen abierto, ¿no?
Ah, vale, porque está bien.
¿Ahora?
Acá caplo yo.
has been so extremely kind to sponsor this session, and our magnificent panelists now. So we were discussing about CEPESH Resource Center for Artificial Intelligence and Cyber Justice, and I really encouraged you to go there. Because, as Mr. Kitairak said, justice is measured by lives restored. And in there you will be indeed able to find a lot of AI and automation tools that are helping us restore those lives. Of course, there were some other quotes that I think need to be taken back to the stage, because Mrs. Babia said, we need systems that listen, systems that empower, and systems that protect. And this is precisely what all the countries represented in this summit have been doing in the past years. Because we are in Spain and we have such strong historical bonds, historical ties to our brothers and sisters in Latin America, and the OECD is also really interested in the region, we thought, why not bring some of the best speakers that we know from the area that can share with all of us the initiatives that they are actually pushing for in their respective justice administrations. And for that, we're going to have this peer dialogue on precisely how these initiatives of Ibero-America are pushing people-centered justice systems in their respective countries. For that, I'm going to invite Carmen Moraes, advisor in the Directorate for Cooperation with Latin America and the Caribbean at AECID, our agency for international cooperation, to please take the floor and introduce their speakers of the session. Thank you so much. Please, big round of applause.
Good morning to everyone, and thank you for being with us today. It's a real honor to welcome you to this session, Dialogue Among Peers, focusing on a justice system, focus on people in Ibero-America. This is at the heart of our democracies, how to have a really accessible, close and transformative justice system, a justice system that listens, accompanies and repairs. We speak about a people's-centered justice system, not only understood as an efficient public service, but as a tool to guarantee rights and strengthen social cohesion. Also, a justice system that can adapt to different contexts, especially to the most vulnerable groups. To speak about people-centered justice means to look beyond and look for a justice system aware of the realities in different territories. Transitional justice is going to be a framework that shows that truth, reparation, and guarantees of non-repetition are not only legal principles, but pillars for citizens' trust, social consolidation, and a stronger rule of law that would meet inequalities, conflicts, wounds from the past, and current challenges is critical in today's democracies. And we're going to have the chance to listen to specific experiences from different Ibero-American and OECD countries that will show how can we journey towards a more inclusive, closer, and transformative justice system. I'd like to thank the panelists for being with us today. I'd like to thank them for their generosity, sharing their experiences and participating in this dialogue among peers. Coele Lieg, responsible of the justice team in the Division of Global Alliances, Inclusion and Justice at the Public Governance Division in OECD. Thank you, Chloe. Roberto Carlos Miral Lopez, legal advisor, magistrate at the Special Jurisdiction for Peace between 2024, 2022, 2024. Maris Vargas, Vice President of the Supreme Court of Justice in Costa Rica, and Álvara Colonna, Deputy General Attorney at the Dominican Republic. Thank you for being with us this morning. I'm going to be sitting with you. Thank you. I believe we need to benefit from this time together to listen to your experience and your background, to have a real dialogue where we can really interact. And I believe this is going to be very interesting. How can we tackle people-centered justice system? I would like to start with a question to all to start the dialogue within a people-centered justice. And in your experience, what's the most difficult thing to articulate a real community justice or transitional justice in context of inequality or post-conflict? And if you have any good practice that we can share, you can share. Thank you. Thank you, Carmen. Before anything, from the Dominican Republic Attorney's Office, would like to thank OECD and the Spanish Ministry of Justice for having invited us to this important event. But also to ICID, a special thanks. Historically, it's been a strategic ally for our office at the Dominican Republic, especially in their support in gender violence and many other projects that we are currently implementing. I believe that in my country, we need to improve, or one of the challenges ahead has to do with coordination, our internal coordination of different state institutions that coincide in certain public services, especially to assist victims. On many occasions, those systems operating differently and with different scopes, and therefore resources are not really focused. So we need to take into account that this coordination needs to be sustained in time, even though changes in government. We need a sustained political willingness in order to attain a better coordination. We are fully aware that ordinary justice, they require more formality, but we also need to adapt the justice system to community justice, where we have higher levels of conflicts. We also need to create systems that respond to local dynamics and that will help us to overcome many difficulties. Institutional fragmentation is one of them. If we really want to provide a more equitable, fairer and closer to vulnerable groups justice system in my country, at the Attorney's Office, we have a motto for this, that is a public ministry focus on people, and we're doing our best to attain this objective. Mari, Roberto, Chloe, any of you, maybe we can speak in order. Thank you for the opportunity to be here today. It's an honor to be with people of such experience and leadership. Thank you for this activity. For my country, for the judiciary, this has been a great experience. We started a digital transformation process before the pandemic. We have quite developed systems, but we have also understood that people-centered justice means a technological transformation without forgetting the public and their situation. So this technology transformation may not give rise to more gaps or breaches for the people. We have designed a methodology for public policies. Those policies were implemented from our offices in the past, thinking with very good will what was best for our communities, but our communities weren't even aware of those policies. So we made a radical change during the pandemic, and now we co-create with different communities and populations. This is very complex, but it requires empathy, as we saw in the previous panels. And United Nations, the High Commissioner Office, also the ICID, and there's a basic element, active listening, to listen to people's problems and experiences. We can very comfortably be in an office with air conditioning and we don't really know about people's realities, indigenous populations, African descendant populations, people working in SMEs that need investment. So we have learned that justice is not just a role, a service, a function, it's an essential ingredient for the country's economy. And if we work well, the country will be okay. We've made significant progress in designing people's focused policies. We are also more open. Until very recently, we were closed among ourselves. We now have a report of the state of the justice system that is an independent observatory, not funded by the judiciary, that make substantive criticism. And they made that there are groups of the population that make comments to us. On the 11th of November, there was a report by CEJA stating that Costa Rica is the most productive country in Latin America. Our index of rulings is higher than the rest, but this is not enough. The challenge is to have a people-centered justice system and to provide solutions to the public. We face a huge challenge and we need to transform thinking in the way we can provide a better service, but closer to the people, not being locked up in our offices, being close to them and letting them feel that we're close. Thank you. Damaris, Roberto, now you have the floor. Thank you. I add to the thanks to the OECD and ICID for making this panel possible. Thank you for inviting us to be here. I come from Colombia. In Colombia, we had a long conflict, 50 years of armed conflict with many different, after many different peace processes is not over yet. We have a society with armed conflict, and one of the main disputes is about the justice systems, those armed groups that defy the state and then try to control the state justice, and this is threatening judges, forcing them to get out of their jurisdictions or pressurizing them to make certain decisions. And on the other hand, those armed groups try to appropriate the community justice mechanism from the communal boards, indigenous or Afro-Colombian local councils. So I like to highlight that Colombia as a country in conflict, one of the most acute disputes is about justice, and the construction of a policy of peace would be to restore a system or take back justice to the justice system, take it back to the state with the possibility to set authorities that are credible enough for all the stakeholders. And here the question was, what is the top difficulty? The lack of trust. People lose faith in the justice system since we can see the great number of victims, violations and crimes. So people don't think that the judiciary could be an institution that could really sort conflicts out. The war is an unresolved conflict, and justice doesn't seem to be able to respond to this. This is the main challenge, and later I will speak about some of the alternatives that we have designed in order to face our current situation. Thank you, Roberto, for the very precise description of Colombia's situation. Chloe, from the OECD, what's your view on all those matters?
Yes,
Thank you very much, Carmen. Thank you very much to ACID and, of course, to Spain for joining the OECD on hosting this session. Our MC mentioned that we are amongst brothers and sisters, so I feel thank you for welcoming the OECD into this family. And I think it's a really important question. So from the OECD perspective, we've been working with countries that are dealing with different conflict legacies, including in the Ibero-America regions, and we see at least 3 challenges in bringing ordinary, community, and transitional justice together. So first, as highlighted, so this system really operates in different logics and also timelines. So we do have ordinary justice for everyday dispute, individual cases, and also the system may also experience some backlogs. Then comes another layer when we talk about transitional justice mechanisms, where it deals with mass violation, truth and reparation, and all the guarantees of non-recurrence, and often over a longer period. And then, obviously, community justice, and also in certain countries, you have specific indigenous jurisdictions. And where it's usually relational, restorative, and grounded in local norms and leadership, whether they're state or non-state, as mentioned. But this also brings conflicts of jurisdictions as well, or similar issues. And at the OECD, so we've been investing a cooperation in the LAC regions over the years, also with colleagues from the Global Relations Department, and we've seen that justice, we've been acquainted through Colombia, but also through Peru, that justice, ordinary justice is indeed impacted by in some territories where the state presence may not be always there, or have difficulties in servicing their citizens there. And and when we see that these different levels of justice are not coordinated, the victims are the men, are where it is the most impactful for them. Victims. And this is where it comes back to the people-centered justice that we were talking about for the last 3 days. The second challenge, it's when it comes to inequality and low trust, it really makes difficult to connect the system. So you were talking about connecting the system together, but if there's distrust among the system, that also is very difficult. And also, and if from the point of view of the people, you don't know in which mechanism should they go. And when you have in rural places, you often also face intersectional legal and justice needs with different barriers. So, and this is where transitional may feel distant and sometimes symbolic. Ordinary justice may feel like it's biased or inaccessible, it takes too long, why bother? And of course, the community mechanism, they may be closer, more trusted, but they don't always have the recognition or the resources or even the links to reparation and services. And just to say that there's this the third challenge is the one related to governance. We have, it's really the importance of, as mentioned earlier, about the coordination of the different processes, also looking at the whole of sector government and a whole of sector approach. We have, and the OECD, there's an upcoming paper on people-centered transitional justice, which we try to tie all these different levels of justice together, and also to action them and to take the approach of a justice service map. So of course, you are all aware of judicial maps, but from taking the people-centered point of view, it's also interesting to develop this kind of maps to identify which kind of services, which kind of entry point to the justice system is available, and to make sure that this is all coordinated. Thank you. Thank you.
Thank you, Chloe. No sé si alguno queréis reaccionar o...
Do we have any reactions, or should we go to the next speaker. The clock is still ticking, but if you feel that any of these points deserves a comment, that would reinforce this action among peers. I believe what Chloe said about the service map is very relevant. We do have one such map in the Dominican Republic, created in a project in cooperation with the Ministry for Women and ACID. And that digital map includes all national institutions, both public and private, NGOs, and the citizens can run a query by province on where institution is located, depending on the type of service they need. Obviously, there are still some challenges ahead because not all the population are digital savvy. And that's why it is important to reach out to the community to bridge those gaps and reach all sorts of citizens, including those who are not internet smart. I think that's an important part of the challenges we're facing, right? Internet literacy and access to justice. Yes, precisely. On that front, we're developing the National Indigenous Policy as part of the executive power, and our Ministry of Justice is here representing us. It's about providing access to justice to indigenous peoples in the ground, listening to indigenous people to understand their needs, and also by running a consultation process to understand their needs according to the highest international standards of respect for human rights. And this is not something we have a tradition on. We've sought experiences in other countries and we have found none. For instance, consultation processes are not in the list, so we developed this consultation process for indigenous peoples to guarantee that we can reach out to these territories, remote territories mostly, to ask these indigenous and native peoples how we can help them, how we can issue rulings that they feel fair and just based on their anthropological background and tradition. For instance, indigenous peoples are exempt of court expenses. But if an anthropologist is going to do a study on these peoples, the community feels separated somehow from the public sector. So we did a transformation to reach out culturally and anthropologically, plus offering services to these communities as part of the process. And we're beginning to work with other communities like Afro-descendants. We've tried to get the government to apply Convention 169 of the LOT to these communities. And that's part of all the new due diligence requirements, right, for that prior consultation with local communities like Afro-descendants or Native communities to reach a consensus within the framework of human rights. So that kind of work you're doing is vital. And actually, we're doing with the funding of AESIR and the United Nations, which strictly hold us to international human rights standards. Well, changing channels again from ordinary justice to a system and administration of exceptional justice, which is a big problem in a country undergoing a conflict and transitioning into peace. So there are three remarks I have noted down. The first one is the challenge of bringing stakeholders to justice, because in a peace process, non-state communities and groups that have raised in arms are expected to subject themselves to the Constitution and the authority of the judiciary power. But there are two big challenges that frequently go unnoticed. The second challenge of these is subjecting public enforcement bodies to the judiciary power, because law enforcement are knowledgeable and they try to apply their own spheres of judiciary, their own spheres of law implementation. So they need to subject themselves to the state law, and also economic powers. And that's the third component. Company accountability for serious violations of human rights. Many companies were left on the outskirts of justice in Colombia. So the first thing I wanted to point out is that justice as a response to conflict is not easy unless the different stakeholders decide to stick to it. And this takes us back to exceptional measures and traditional justice. In the case of Colombia, we tried to create a special independent tribunal, independent in terms of financing and justice administration. And it comprises its own research and investigation mechanisms, closure mechanisms, their own set of attorneys. And that makes me think, well, Damaris, you made me think about a few elements that might be relevant. First of all, courthouse integration. 60% women actually brings the gender issue very much alive. And two other unprecedented facts in Europe. 20% of judges, of magistrates in court are indigenous and Afro-Colombian descendants. So it's not just a matter of interlegality with native or indigenous justice. We have indigenous magistrates and Afro-descendant magistrates, which changes the balance in the courthouse. And also, we don't do the whole investigation. We can use macro cases. We have macro cases. We do not investigate individual cases. We're considering, for instance, a single case for 6,000 abductions or 20,000 deaths, as if we were talking about class action. So it is important to concentrate the administration of justice to go where ordinary justice cannot go. Open millions of individual actions to investigate the material perpetrators would be very difficult, whereas in this type of class action, we use the Rome Statute of the International Court of Criminal Law for crimes similar to genocide or crimes against humanity, to address the actual planners, the main perpetrators in hundreds of crimes classed under one case. And then, as you mentioned, restorative justice, which involves opening processes to massive participation of victims. That kind of class action can only be achieved when victims have psychosocial support and legal advice. We provide attorneys to bring these victims to the process. They don't have to finance their own defense, which is sometimes an obstacle. And as part of that participation, victims are a part of the decision. They participate in the whole process and also in determining the penalties, which are usually not prison, but projects meant for reparation. So these tools are an attempt to make justice more flexible in a context of transition. Thank you. Oh, thank you, Roberto. Do you have anything to add, Chloe?
You see, there's a lot of challenge. It feels like I need to breathe. We really want to help the region, and one of the starting points, as mentioned, is having this flexible, people-centered framework. There's this guidance you heard about the OECD recommendation and etc. So this is where we try to apply this lens, and there has been so many already good practices that we heard. We trying to under this work stream to try to put all the principles of people centricity, of transitional justice, ordinary community, and also justice to reinforce each other. And one of the first pillar you saw is like how to design, how to understand what are the needs. There are multiple needs from different level of justice, and this is, we've worked a lot with Colombia. We had a few projects there, and really wanted to highlight as part of this discussion that there's the legal need assessment and all the local justice communities that really had helped identify what victims of the armed conflict actually need, whether it's documentation, you have land restitution, tribunals as well, and also all the protection and psychological support. And trying to connect all the community-based and restorative approach together. We also heard, like, for example, also in Guatemala, there's a lot of mobile units as well that are trying to go to these regions. So it feels like this peer dialogue is very appropriate, and I hope that it's not too overwhelming. At the end of the conversation, we will have a very good, roadmap going together for the region, for the Ibero-American region, please.
Muchísimas gracias, Chloe. Sí, ese mapeo yo creo que es.
Yes, of course. Of course, Chloe. I believe that this is fundamental work to be done. So, from the compared perspective of the OECD, how is access to justice perceived in Ibero-America, and what public policy drivers would be required to favor the implementation of those good practices from a global perspective?
Also a very important question. But I have to start with two quick disclaimers. First, of course, as you know, it's very difficult to generalize about Ibero-America. I mean, yes, there's a lot of shared legal tradition, historical influence, but very recent, many countries have taken different trajectory and bringing this it's a diverse region. And in terms of institutional capacity or justice models, and even how countries have experienced conflict or inequality and democratic transition. Second, and in order to take a really truly comparative perspective, it's very still challenging because we lack sufficient and comparative data. We have the recent efforts from the Ibero-American Alliance on Access to Justice, and with the Pathfinders initiative and also the World Justice Project, they have this very important report. I think it was launched in 2023. Yes, thank you. And they're promising step, but we need more systematic, disaggregated, and integrated data. Having said that, we still, through our work, we see a pattern across the region, and we usually say that countries face similar access to justice challenges. The difference is in scales, and not in type. And indeed, I've mentioned the World Justice Project, that they had in some of the countries representing here in the room, most of the legal problems in the last 2 years were related to a lot of land or housing, also some consumers issues. And out of that, roughly, only 25 to 30% of the people were able to obtain help. And most of that in the second report from the Justice Data graphical report, only half of them went to a dispute resolution body. So there is this is a very clear message that we heard. It's not about the law. We have very good, strong legislation, but it's about the people and how they navigate and trust the system. People will only seek help if they believe that justice will work for them effectively, fairly, with dignity, and in a reasonable time. And this is really my first central point, is trust as a key driver of access to justice. Low trust discourages people from seeking help. But we also know from a recent OECD report related to trust that high trust encourages engagement and also strengthens the rule of law. So this is very essential point if you're looking at policies on access to justice. We have, as mentioned, the OECD survey on the drivers of trust. There have been something particular for the LAC region, and while the confidence in public institution drops to 36%. So it's a very low one. And but we heard also, as again from the Public Governance Directorate, we also think that this trust deficit is a major governance challenge. And, but we're happy to see that in the region you are working on some of these drivers of trust to strengthen both the competency of the system, making me more reliable, responsive, and timely, but also on the values. We were talking about integrity and accountability, also the transparency and the openness of the process. And very recently, our head of division went to the first international conference on open justice as well in Santo Domingo, and we were we saw that how there was the political commitment and very practical trust-building initiative and innovation that was evidenced across the region. And importantly also that we heard in the last 2 to 3 days, that there is also in the region a growing consensus that justice must be treated as a public service that is built around the people, and that is delivered as well through this continuum of easy to navigate services. And we will be happy, so we are working on the basis of the 5 pillars recommendations. We are working on developing the state of the people-centered justice in the region. So we'll be welcoming we would welcome some more practice from the region to make sure to integrate it into this report. And if I can just say one more thing, this roundtable these last few days were also organized to ensure that to advance this people-centricity framework. And one of the main pillars is having the high-level commitment, the policy commitment to advance, where also mandates align. And this is what we're trying to do when we organize this roundtable. We had the first day with high-level political commitment. It was the conversation was very impressive. There was a lot of coordination. The second day was about this policy, and today is about the technical. And this is where we try to advance this approach from high-level commitment to really on-the-ground experience coming together. Thank you very much.
Muchas gracias, Chloe. Voy a pasar.
Thank you, Chloe. I'm now going to ask Roberto, and then we have a conversation. Roberto, you've already introduced it in the previous comments, but based on peace processes, experiences, and transitional justice, what are the main achievements and the main challenges you face in Colombia in order to have a more accessible justice system closer to the victims and communities?
Gracias por la pregunta.
Thank you for this question. I believe that what we have achieved is to integrate regional experience. I'm speaking about the fact that we could unite the experiences of the Chile and Peru Truth and Reconciliation Commission. There was a large Truth Commission. We have a unit that looks for missing people. We learned from Argentina. We have justice systems that learned from the continental experiences of the court cases developed in the past 40 years, especially focused on restorative justice. We have also introduced in our restorative justice the experience that come from criminal law after 40 and 50 years of discussion about restoration, about victims' participation at criminal cases. So I would bring the idea that our main achievement is that we have been able to unite the experience in the region, the experience that was closer to us, as a challenge, but also as an achievement. One of the tools we used was the internationalization of the justice system. By this, I mean that in our special system in our courts, we can appeal to the Statute of Rome, we can appeal to international law on human rights, to humanitarian international law, since we know that part of the conflict requires the application of these regulations. And I want to make an invitation here. We see the important connection of for us the OECD when balancing this huge asymmetry in our countries between the local communities and transnational organizations, and on many occasions they are also crossed with discussions on development, resources explanation, environmental issues that affect those people living amidst the conflict, but facing those huge agents that have greater capacities than the local communities, where the court cases are not in the local areas but on third countries, or arbitration processes that take place really far from the local communities. So I believe it's very important that this type of organizations allows for mechanisms so that communities can access this global justice administration. We have this strategic litigation, but this is just one isolated case made with a great effort, but are mostly the exception. And small communities and regions cannot get in transnational judicial discussions or debates. And I believe any effort that we can make in this type of forum to make ways, avenues, or projects that would allow this global dialogue that is more balanced, that so far is quite unbalanced, that could really help in the construction of peace and lasting peace in our countries. Thank you, Roberto, for your interesting reflection. And just to continue with the mapping of different experiences from Latin American and the Caribbean countries, I'd like to ask Damaris if, taking into account all the experiences in Costa Rica and the Dominican Republic, how was the closing of the justice system to local communities, guaranteeing that the legal services really meet their daily needs? Do you have any learnings or experiences that you can share with us in relation to the access to justice and the justice system to the most vulnerable populations in my country? For many years, we've been implementing community attorneys' offices. They have allow us to take the public ministry to the most vulnerable sectors of the population. It was not implemented at a national level, but at the capital city of the Republic for many years, especially at the National District Attorney's Office. We have 14 community offices on top of the headquarters, and I believe this headquarters is now decentralizing services, and they work with smaller cases in order to make the system more efficient. Our general attorney is now going to present this plan at a national level. In the last weeks, we opened up 2 more community offices. We realized that once those offices are located in certain areas, after conducting studies about the conflict rate of the area, we see that the conflict rate or crime rate decreases just by being there, by being a presence of authority. And people are happy with this. They feel that those services are closer to them, and many disputes are sorted out and don't finally get into the ordinary or traditional justice system. It's estimated that in 1 or 2 years we will be able to conclude the project to set 26 more of those community offices at a national level. One was located at Susua, a very tourist area in the Dominican Republic, in Puerto Plata, and it was one of our biggest pain points for the number of cases of sexual exploitation of boys, girls, and teenagers, and the conflicts with sex workers. So thinking about this situation and thinking about the groups of population that really need it, we will locate those community offices. We also have units specialized on gender violence at present. In order to complete the whole geography of the 25 units currently working, we might add 14 more, and those units work with physicians, doctors, therapists, everything that a victim needs, not to have to move anywhere else. And this project will take place in the next 2 years. As I said, there are still 11 more to come. We've been also closely related to the civil society. In the Dominican Republic, there are cases where it's been very important for conflict resolution of using alternative means of justice. For example, with a community officer, with a mediator, to be used with a smaller cases, and that's a common and community effort that shows how important interinstitutional cooperation is, and also the role of the civil society is critical. We also have the FINARET, a national system of mediation for conflict solving. It's located in Santo Domingo, but it also eliminates the backlog related to judicial processes. Still now, at present, today, we can say that we have created the National Department of People's Care. We have redesigned our services so that they are more agile, more transparent, and more focused on the specific needs of the public. With this transformation, that is digital transformation, we will have the internal electronic case management of the Republic, where we will promote transparency, as Chloe said, to decrease the level of mistrust of people on the justice system. And this is a rather ambitious project. The customer attention care requires staff to do a digital surveillance, detecting with a technological team in the social media any type of risk that a potential victim of gender violence may have. And as a general objective, this system looks for a standardization of processes so that services provided at the capital city would be the same throughout the country, regardless of the remote area they might be living in. This would generate management indicators and also will speak about the performance evaluation of attorneys, and we can have strengthening of the role of our institutions and to end up having a people-centered justice system. I could speak forever, but I can see that we're running, or might be running out of time. And excuse me, and I just have to say this. We have the National Service of Victims' Legal Representation. It started 18 years ago. It was part of the Attorney's Office, but it was stable, always with 42 lawyers at national level, and services were always delayed. At present, there's a tender process, and now we have 100 lawyers, men and women, with a special training on victims, and by the end of the year, they will be relocated at all the countries, provinces, so there will be free legal representation for all victims of crime at a national level. I'm sorry for having interrupted you, but we started a bit behind, and I believe that it's interesting to also give the floor to the audience. Damaris, maybe to give a little bit of background. Costa Rica is a small country with our own army since 1948, and justice is done in such a way that in Costa Rica, within the judicial power, we have the general attorney, the ombudsperson, the technical and forensic law enforcement offices, and also the Constitutional Court is within the judiciary, and therefore the key is in the way we articulate all of those institutions. All indigenous people have legal assistance. People without resources, they get specialized free legal advice with translators, with all the services they might need. And this is what we created a long time ago. We have a special act for this aim, that hearings should take place at indigenous territories, in places where conflict is happening, so that people don't have to look for justice to our courthouses, but we go there. Once we are there, is not only to decrease their cost, but the person that is going to issue a ruling knows about the context, how they live, they get to know them, and people get to know the judges. So we have reformed procedurally all the matters. We're specializing criminal, domestic violence, all sorts of branches of the law, and that was approved by the Legislative Assembly. And oral hearings allows that we can be issuing justice face to face, and directly this allows more people-centered justice system. They are seeing us, and we document, of course, our decisions. And if on top of that we go to those areas where conflict takes place, that makes life easier for those in need of a justice system. One of the situations, in statistically speaking, at indigenous populations, we have the higher rate of domestic violence. And someone told me once, my husband is abusing me, and I asked her, why don't you present a claim? She would say, I don't have money to do so. I need to borrow money from him to go there. If I need the money to present the case, he will kill me, so I better don't do anything. So we sent virtual stations in indigenous territories and in remote areas of the country, and there is someone responsible there. So those that need a justice system, they can make a direct contact, and the public lawyer can take care of this on a periodical basis. When the hearing happens, you have all the team needed there where the conflict was generated, very near to people's lives where things are happening. We've been also working with the concept of open justice, so that people can see us and being transparent in the information we provide, using plain language, but is not only the use of plain language, but we always need to speak in a simple manner in every situation so that justice is for the people and not for lawyer to lawyer, but for those that really need to understand what we're saying, and we need to help them understand it. In summary, I believe trust should be developed. The public needs to know about our change, about the way we want to improve, so justice becomes resilient. Justice changes, and all the criticism to the judiciary, and Costa Rica is not the exception, it would be for us not to feel attacked, but to have a spirit of transformation. Thank you. Damaris, I believe that after we have seen all the challenges and the situation in general, all those good practices that you have all presented in this dialogue are very interesting and open up an avenue for hope towards the future. Roberto and myself, we spoke about the transparency, the use of plain language, which is critical for the public to access the justice. We just have 4 more minutes. It's a pity. Time flies when we're having a good time. I believe it'll be now the time for the audience and a very brief conversation with them. I believe someone wanted to participate, so instead of continuing with the prepared questions, we're now going to give the floor to the audience. First, I believe José Suinagua, President of the National Court in Ecuador, and Mr. Botero, General Secretary at COMHIP. I don't know if they are still in the room. And then we give the floor to the next. Thank you, Carmen, for this time, and thank you, all of you. I am Gloria Manzotti from the UN Program for Development. Luckily, we also have good experiences in countries like Dominican Republic, Costa Rica, and Colombia. But today, this is to contribute from a regional space. Thank you, Chloe, because we met in the past, and that's why we're part of the coalition for the access to justice. And it's wonderful to see that the Dominican Republic and Colombia are 2 of the countries that were pioneers in Latin America through their contributions. In Colombia, with an initiative that also responds to one of the peace agreements, that listening to peace, and is the new agrarian legislation. But I will not dwell on this now. This is also the Ibero-American Alliance of Access to Justice. Why am I presenting this? This is the result of an effort and of many of us here in the room that allow us that in a context where backlog, reduced public spaces, public premises, well, nevertheless, we can be together here in the national community and regional institutions, the Conference of Ministers of Ibero-America, and many other instances, but also the civil society. And we generate new knowledge, but we can speak about the possibility to push those agendas forward. How can we understand those regulatory frameworks as the Judicial South American Summit, or how can we really go to the consolidation of the framework, Ibero-American Covenant on the Access of Justice, all those instruments, how can we go on developing them, but implementing them in specific actions in different countries? And with this difficult situation that you presented on the 3 experiences of your countries, with the idea of co-creating through active listening, through plain and clear language, opening up collaborative spaces. I'm going to stop here. Thank you, Carmen, for giving us this time. We've been able to share with your organization many of those experiences, and a big applause to all these panelists for showing us real evidence and the reality of the challenges we will have in the future as a region. Thank you.
Hola, ¿qué tal? Muy buenas tardes. Mi nombre
Hello and good afternoon. My name is Evan Cantul from the Office of the UN Against Crime, UNODC. So I have both a remark and a question that I will try to express briefly. I come from Mexico, and I find it very inspiring and enriching that vulnerable groups and their priorities are put on the table. Not only Afro-descendants, but also indigenous peoples, coastal original populations or communities. And in a round table that deals with access to justice, I'm very much recognizant of you dealing with justice for these communities. So I just loved that fact, and I appreciate the fact that you're discussing that. So that's my remark. Here comes the question. We've been talking about access to justice and people-centered justice and providing a service to these citizens. But can we focus for a moment on institutions? Institutions focused on people, or people-centered institutions? Because certainly we're providing a service to citizens, but to keep people in the core, at the heart of our business, we also need to consider people within the institutions. We've been talking about service delivery and active listening, which are, of course, key substantial concepts as they allow us to have better impartial communication with our final users. But also, I've noticed that those values and principles are not applied inside the institution. And I think it's vital to bring them back into the discussion when we talk about people-centered justice. We might think about justice within the institutions that provide justice. So beyond models facilitating access to legal counsel or psychological assistance in context of transition, individuals who have been exposed to serious cases, I mean, legal practitioners that have been exposed to very harsh cases and need psychological and emotional support, people who deal with cases of gender violence, I don't know, parent leave. I'm just thinking off the top of my head. Do you have any practices you can share to focus on the staff within these institutions and also keep them at the heart of the institution? Thank you. Should we go in order from Chloe all the way back here?
For your words and for highlighting this. I mean, this is of course very important, and I can only ask you to turn to the toolkit on access to justice that we just launched, where we look at different practices under the pillar. And you're mentioning this. Well, we mentioned in a way two of these pillars: the governance infrastructure and how to build the institutional foundation for people-centered justice. And you will see different practices from OECD country, from Spain, and they have in their Justice 2030 plan, but also in Portugal they have an example of the NGO. But then you mentioned people empowerment. The pillar looked to people empowerment. In our recommendation, people empowerment looked at the users, the potential users, but also looked at the staff. And here I can also direct you to look at also Portugal's example in a toolkit where they looked at these different competency-based training plan, when of course they put inside technical legal updates, but they also have a continuous training plan on transversal skills like stress management, decision making, and communication. And it is true when we talk about vulnerable population, it is also important to have this kind of psychological support. And we heard some in time talking with judges how case after case is difficult. I myself was an asylum judges in France, and case after case you hear about all these stories, and it's just even your decision making can be affected, you know, and in different ways. Either you block completely, you don't want to hear anything, or you really lean into much more into the victim. So it is very important to have a staff that is strong, especially in this kind of cases, and it's even more difficult. Sorry. Thank you.
Roberto.
Bien. No, sobre lo que acaba de decir Chloe, nosotros en la jurisdicción tuvimos un problema.
Just as Chloe was saying, we had a serious issue in our jurisdiction to the extent that one of our judges recused herself due to mental health issues. So at the time, we launched an internal mental health program, and after a year, most civil servants in our jurisdiction have joined in search of help. So for health professionals, that kind of support is very normal, but not necessarily among attorneys and judges. So we had to launch a program for that specific purpose. Damaris? Yes, in our case, we've seen the same situation, a lot of demotivation of defense lawyers, prosecutors, judges. So 3 years ago, we created a legal staff well-being program. For instance, Casual Friday. Casual Friday has had a huge impact on the population when it would feel like not a very significant measure. It piles up on top of psychological help and mental assistance. So once you're saturated with all that harshness of real life, just a Casual Friday can greatly improve the staff mood. When citizens come to an office, they will get a service, and we expect them to receive a human service. And legal professionals should be proud and happy to be part of the service in the system. So we're truly focusing on our human capital and the pillars, the OECD pillars of justice focused on people, or people-centered justice. And if we want to bring ahead these processes, as complex as Roberto was saying, we need to be fully prepared. I mean, defense attorneys for cases of violation of human rights are exposed to a lot of harshness. And it takes a lot of support, because we need to be ready for these harsh situations in our countries with a holistic approach. It's not just about citizens. We also need to look inside, as you said. If we feel good, we can offer good justice. Thank you, Damaris Alba. I'm already getting glares from the timekeepers. Yes, I agree. I would love to see that self-care you're implementing in Costa Rica, Damaris. In 20 years, I've been working at the district attorney's office. I have never seen such a program. Obviously, nobody can offer what they do not possess. If a professional does not specialize in their process, if they have no empathy, if they don't have the calling of service, they're doing a disservice to the population, particularly vulnerable communities. So yes, we do look to the inside, and we support not only prosecutors, but also administrative staff working with prosecutors, which are perhaps the first interface citizens get to see when they come into our offices. So yes, we take care of that too.
About saying, so it's not about this big plan. So of course you can have well-being big plan integrated into the competency training, etc. But you do have quick wins. Casual Friday. So if you have this, so it's just thinking this little measures that could be implemented even just within courts. You know, we had all these chief happiness officers. You know, sometimes it makes you laugh, but actually, when you think about it, it's very important to empower someone from also the staff to try to think of these little quick wins and measures. So it was important.
Muchísimas gracias, gracias a todos. Yo creo que de aquí podemos sacar como tres grandes conclusiones, ¿no? Es muy difícil.
I think we can draw three large conclusions here, although it's very difficult to summarize. But that active listening, that open justice, and that need for reaching out to citizens is very valuable, albeit hard to achieve. And then it should be part not only of public policies, but also part of technical plans to make those policies truly effective. And last, that way of sharing lessons learned, good practices, holding global dialogue in search of peace and equal access to justice to prevent that kind of asymmetry that is so frequent in Latin America and the Caribbean, right? I would say that these are three major concepts we can save from this whole dialogue, beyond all those good practices and very interesting initiatives you shared with us today. So thank you very much, and to see you soon is my hope.
A todos los panelistas.
To all panel members, it's been a true privilege to have you here in this dialogue on how to advance people-centered justice in Ibero-America.
All right. So I told you at the beginning of the morning that this day was going to be a little bit different than the other two. We're going to have some parallel sessions, and precisely because those parallel sessions couldn't be seen in the streaming, what we would like to do now is to just call for some brief, very little conclusions to the moderators of those sessions, so we can actually know a little bit of what was discussed there. One of the sessions was focused on measuring performance of people-centered justice. And the moderator for this session is Maaike de Langen, who is a senior policy advisor at the OECD. And I would like to request you a big round of applause for Maaike, for her to deliver the conclusions of the session. Please, Maaike.
Okay. I hope you had a good session here in this room. We were certainly very energized in the parallel room where we had a session on measuring performance in the justice system. And this was really a working session where we presented a lot of our ongoing work with our partners, and we got some reflections from two of our panelists and from the room. And what we presented was the justice measurement framework, which is meant to be a relatively simple framework to capture a very complex issue, which is the justice system. And it aims to measure performance of the justice system at three levels, or organize data and measurement of justice at three levels. At the level of what governments do, the levers of policy, the government tools and system characteristics. At the level of service delivery, where people actually experience justice, where people resolve their problems, and where there's a whole range of justice providers who collect different types of data. And then ultimately at the level of society, of what the justice system as a whole contributes to society in terms of whether people are able to resolve their justice problems, whether the justice system as a whole contributes to fairness and trust, and whether people have access to what they need to resolve those problems. So that was the framework that was presented. We then had a bit of a more in-depth discussion about the outcome indicators, the overall contribution that the justice system aims to make to to society, and then we had some reflections on that framework, and that reflections, I guess, drew attention to the complexity of this. So we had some examples shared from the Ministry of Justice of Spain, who has really very impressive work that has been done over the past years for different types of services and different types of online tools and services, and how they then use the data that it generates to build dashboards to give different actors a good view of what's happening, what the data is telling them. At the same time, all that data is available, but it still needs to be connected to those broader questions of outcomes in society, and really what are the people-centered indicators that are needed to understand what the justice system is delivering. We also had a reflection from our colleague from UNODC, Anna Giudice, and she reflected also on the connections to the criminal justice system. So the measurement framework we developed is, we've been having a lot of discussions about the connection between, or the applicability, I would say, of some of the same concept to civil justice and criminal justice. It came up in the discussion again. We didn't solve the issue, but we are very well aware of that, of course, some of the key concepts and the conceptualizations that underpin a measurement framework like this play out differently whether you're talking about civil justice, administrative justice, or criminal justice. So that was sort of the presentations, and we had some interaction with and comments from the floor about understanding the framework better, and also about the broader connections to democracy and autocracy, and how the justice systems, how actually measurement, or if I say it correctly, how our assumptions that we underpin in those, that underpin the framework, whether they can actually be useful to also understand the relationship between the justice system and the political context, the tendencies versus autocracy or versus democracy, and those correlations. So very important aspects you also take into account. So as I said, our work is an attempt to make something very complex simpler. Some of the questions alluded to some of those complexities. One of our conclusions was there's more work to do. There's a lot of analytical conceptual work to do, but primarily also there's a lot of testing to do and a lot of trying to turn this into practice, working with countries to operationalize it and make it useful. And then finally, a lot of this work done by the OECD on the policy indicators will result in the report on the state of people-centered justice that we hope to share with all of you in the course of next year. So to be continued.
Thank you so much, Michael. And now I'd like to call to the stage to Mrs. Atieno Diambo, Director of the Legal Empowerment Fund and the moderator of the session, Delivering Justice in the Context of Disasters, including Extreme Weather Events. Thank you so much.
Thank you, everyone. Our session was actually really good. I called it the brain trust because there were very practical reasons and practical examples given about how justice can be delivered in the context of disasters and extreme weather events. From Spain, sorry, my mic is kind of on and off, sorry. Yeah, so from Spain, we heard about the digitization of the court system and how this digitization has really helped prevent the secondary effects of disasters. When disasters happen, if people don't believe in the justice system, then sometimes you end up in situations where violence occurs, exploitation. So one big example from Spain was once the system is digitized, then it can be used anywhere. When floods happen, when disasters happen, you have situations where courthouses are affected, police stations. So having a digital system, a digital justice system, really prevents secondary effects. In France, a very interesting concept that which I think should be done globally is they actually did a survey of all the citizens. The survey was sent out to the citizens of France to ask them, how do you what do you think of the justice system? How do you access justice? And those responses are what has helped them to craft the way in which they're responding to disasters. In Turkey, it was really interesting to hear about how after the big earthquake in 2023, it was literally all hands on deck. I think about 150,000 judicial personnel were displaced, but that didn't grind justice to a halt. What they did is partnered with different counties and communities to help and provide the justice system to continue working in those regions. But also there was a really interesting thing they did is where all the affected justice personnel were taken out and were actually helped and relocated. So it was really taking care of those that keep the wheels of justice moving, at the same time partnering with other regions that were not affected. And then we had in Australia, where the main focus was really on collaboration and making sure that the people affected, that the voices of people affected, marginalized populations, are really key in coming up with policies, in coming up with ways in which they can deal with the disaster preparedness. A really good and interesting thing they also have in Australia is podcasts. I think when you look at how the world is moving, whether it's with social media, everybody listens to podcasts. I think I'm one of the only few people on the planet that doesn't listen to podcasts. But the fact that they're taking on and actually working with what people are using, the way that they're communicating, to me, podcast is an amazing way to get information out. So I think in our group, to me, what I felt was, and then we also had a bonus person in our group who was Marielle Favier, the Deputy Mayor of The Hague, who really talked to us about the new system they're looking at and trying to make sure that climate justice is part and parcel of the work that they're doing. So, for me, in conclusion, what I did say was that this amazing brain trust that were part of this dialogue that I moderated, the different ideas and how each country is responding to disaster and access to justice in those situations is very different, but at the same time, it's all people-centered. And what the common thread with each and every one of the preparedness that they're taking is that people have been put in the center. People are actually helping and shaping how governments are responding. Thank you.
Thank you so much, Mrs. Oyambo. Well, these are the conclusions of the morning. Now I think a lot of us are a little bit hungry, so we can go and take our lunch break. Thank you so much. We convene here in some 80 minutes. Thank you.
We now invite you to the luncheon pause. Please proceed to the designated area in the foyer outside the auditorium.
Les invitamos ahora a la pausa para la comida. Pueden dirigirse a la zona asignada en la antesala del auditorio.